Welcome to Bridging the Gap, Law, Therapy, and Justice.
Hello and welcome back to Bridging the Gap, Law, Therapy, and Justice with attorney and licensed marriage and family therapist, Caitlin R. Burgess. Caitlin combines legal and clinical insight to help families, attorneys, and courts navigate high conflict situations with understanding and care. I'm Kevin Rosenquist. Today we're talking about child custody evaluations. Caitlin will explain how they work, what courts are really looking for, and how mental health professionals fit into the process. Caitlin, good to see you again.
Hey, Kevin, great to see you too.
Let's start with the legal side. When a judge orders a custody evaluation, what purpose is it meant to serve in the broader family court process?
Courts are very busy here in California, as I'm sure they are all over the country. Our family courts are so busy. And sometimes a court just needs essentially a highly trained investigator into looking into the health, safety, welfare, and best interests of the child or children, often involving custody and visitation, sometimes other issues as well, impacting the child or children involved in a case. So they're really looking at an investigation. They need more information, and they want a specially trained forensic child custody evaluator to weigh in and provide recommendations.
Who usually conducts these evaluations and how are they chosen?
Yeah, that's an important question. So all child custody evaluators, Kevin, must meet the qualifications, training, and continuing education requirements in California Rules of Court 5.225 and 5.230. So they're very stringent requirements here in California to be a child custody evaluator. You need to be either a licensed physician. If you're a licensed physician, you must also be either a board certified psychiatrist or have a finished residency in psychiatry. You can be a licensed psychologist, an LMFT, an LCSW, or a professional clinical counselor who is specially trained to assess couples and families and that sort of dynamic. There are exceptions to this in certain circumstances, but generally this is what is required by the legal system in the courts.
Okay. What are the main factors that evaluators are assessing when they're making recommendations about custody or parenting time?
They're assessing a multitude of factors. So we have to have our specialized training. So to become an evaluator in the state of California, you have to have 40 hours of education and training in subjects that are relevant to child custody evaluations, such as the psychological and developmental needs of children, family dynamics, significance of culture and religion of on the lives of the parties and the children, sexual abuse issues, safety issues, domestic violence. So you have to have the ethics of child custody evaluations, how to write reports, forensic interviewing for children. So in California, you have to have this 40 hours of advanced education and training in these subject matters above and beyond what are what my licensing, my regulatory body, the Board of Behavioral Sciences, the BBS requires. You have to materially assist another qualified child custody evaluator on how to do these evaluations. You need to assist them on 4 separate evaluations. And then you have to have 16 hours of advanced training in domestic violence from the get-go. And then every year you have to have continuing education in domestic violence. So 4 additional hours of domestic violence training every year and 8 hours every year of continuing education in custody evaluation. So it's really an ongoing process that requires a lot of us as mental health professionals.
So how do evaluators gather information from such different sources? You're talking parents, children, teachers, therapists, all of that.
Yeah, it's a really lengthy and involved process.
I would imagine.
Yes. And you need to maintain your neutrality. Your focus is always on
Yeah.
the children. There are really strict rules regarding communications. There and sort of how to go about this process. So generally, for me, the way I was trained, and I think pretty much standard procedures are, typically I'll interview each of the parents 4 or 5 times in a full custody evaluation, usually at my office, sometimes via Zoom or another telehealth platform. So 4 or 5, maybe even 6 hours of interviews with each of the parents over like 4 to 6 month period for me. I'll do home visits. So each parent go to their home, see the kids, tour the neighborhood, spend about an hour at their homes usually. You want to review documents, CPS records, police reports, arrest records, criminal records, if needed, school records, psychological records. Often, children are involved with their mental health providers, or the parents are involved in with the mental health providers. Speak with collateral contacts. And then you write the report. So it's very involved process. I let the clients, or not the clients, I let the parties know at the very beginning, because the client's essentially the court for me. But the parties, the litigants, I'll let them know at the beginning what my process is. It's outlined in my informed assent agreement. And I really want people to understand that it is a lengthy and involved process.
How is communication between attorneys and evaluators, and what might help that collaboration stay transparent and ethical?
Yeah, thanks for asking. Well, there are no ex parte communications, generally, very few exceptions to that. Ex parte meaning if an attorney sends me an email, I'd like them to copy the other attorney. If they're in pro per, I'd like them to copy each other. That's outlined in my contract, require them to actually copy each other. Any documents I receive need to be provided to the other side. I need evidence of that, whether it's a proof of service, or, if you're sending me an email, or there's a uh, access to a Dropbox folder, for example. Everyone has access to it, so there are no secret documents being channeled to me by one side. Definitely have a meet and confer at the beginning of the process. So meet and confer with the attorneys and the parties. The parties don't have attorneys with the parties. Meet and confer so we can be really clear what the scope of the evaluation is, answer any questions they may have. Uh, at the end of the process, when I submit my report and recommendations, meet and confer with the attorneys or the parties after that to try to reach a stipulated agreement. Transparency, everyone can access my record in the end if they need it. So, very careful about that record, and making sure we're complying with the California rules of court, the laws of this state, and ethical codes.
Where does therapy fit into the picture while an evaluation is underway?
Often as part of my evaluation, if I'm doing a comprehensive child custody evaluation, the court will want me to provide recommendations for services for the family. And I often do require, services such as co-parenting counseling, because if the family is at the point where they're needing a child custody evaluation, generally there's a lot of conflict. Not always, though. I
Yeah.
don't always recommend these therapeutic interventions at the end of the process. Sometimes people are already in therapy during the process, and that can be super helpful, because then the therapist can be a collateral contact to my process, and I can, get a lot of useful information, assuming that the parents sign releases. Like, for example, if they've been in co parenting counseling, or if they're simultaneously in co parenting counseling, I can speak with that co parenting counseling, and I can be like, hey, are they showing up on time? How is it going? Are they
Hmm.
able to communicate? Are they able to reach agreements? And it can be really valuable information. So it
Okay.
can be going on in tandem, Kevin. Like, that you
Okay.
don't have
It's
to,
tandem.
yeah,
Yeah.
you don't have to stop all your therapy in the middle of the process. Therapy can be hugely helpful for litigants going through this process. So it can be going on simultaneously, or maybe it's not going on simultaneously. It's gone on in the past, or maybe there's never been any therapy, and maybe as the evaluator, I feel like that would be helpful for the family, so it can occur after.
So the therapist can participate as long as the parents sign off on it.
Yep.
Okay. Many parents feel anxious about being put under a microscope, understandably. So how do you help families engage honestly without feeling defensive or perhaps fearful?
Well, I think they're always going to be anxious. I mean, I think litigants are anxious when they're in the middle of this process, as they should be,
Sure.
because it feels, well, there is so much at stake for their children. And I think uh, just, assuring them, establishing a good rapport, helping them feel confident in me. I like to be very transparent. Let them know there is a complaint process. Of course, I'd always like someone to come to me if they have any concerns about my process or the ethics or questions. But, at the end of the day, I'm accountable to the Board of Behavioral Sciences here in California. And if client isn't happy, they can complain to the board, they can complain to the court. But I hope never gets to that point. I really always try to do the best job that I can and follow the guidelines. The AFCC puts out a parenting plan evaluation guidelines for 20, I think it was in 2022 that they came out with those. So there's the rules of court. There's procedures outlined in the rules of court. So I feel like as a professional, as long as we're following the guidelines of our professional associations, following the rules of court, keeping law and ethics at the forefront and making that clear to the client, I think that provides them a lot of assurances and can help them feel calmer about the process.
Okay. Yeah, I mean, obviously, a lot of different personalities out there, and some are going to be more defensive than others. So I imagine each case is its own unique snowflake in a way, right?
It is snowflake. Yeah. I mean, I never thought of it like that before, but you're right. Every family is different. That's a good
Yeah.
metaphor, good analogy. Yeah. It's like every family is so different. And people will ask me sometimes, whether I'm in the role as therapist, not as an evaluator, but if I'm in the role of a therapist, people will say, "Hey, what do you think's going to happen?" And I'll have to say, "Look, I never know what's going to happen. Every case is different. Every court is different. Sometimes I'm only getting one side of the story. You can't predict outcomes, but you're right. Every family is different, but the laws and the rules are there to guide us. It's like a recipe following a cookbook, so to speak, a recipe in a cookbook.
Hmm.
Um, so if we're going to speak in metaphors and so forth, you follow the law and you follow your ethics guidelines and you do your best, and hopefully when you follow those laws, rules, procedures, ethics, we're going to get some good outcomes that can promote settlement for the family. That's the best
Yeah.
case.
Okay, so once that report is complete, what typically happens next in court, and how much influence do these evaluations carry in judicial decisions?
They actually tend to carry a lot of influence, although they are recommendations. I am not. Sometimes people say, "Well, your orders." I'm like, "They're not orders. These are not orders. I'm not a judge. They're recommendations." And in a best case scenario, people settle. And we have meet and confers after I turn in my report. The parties can file objections to my report, but I meet and confer with the parties and the attorneys, and I want to listen to their feedback and can make changes, and I often do make changes. And in a best case scenario, there's a stipulated agreement, and then the evaluation has accomplished its purpose. No one's hopefully fighting anymore. They've reached agreement about what I've recommended. But that being said, the court makes the final determination regarding custody. They make the orders. They make the legal determination. And these evaluations can be challenged by other experts. So someone can hire, if they're not happy with my report and you want to hire another expert to challenge my report and look at my process and look at my procedures, and they can say to the court, "Hey, Miss Burgess didn't do this, she didn't do this, she didn't do this, we don't agree with these recommendations," and we can go to trial. And then I would likely testify, and the work product review expert would testify, and maybe the court won't follow my recommendations in that case, or another evaluator's
Yeah.
recommendations. But hopefully they settle, and that's not what happens, because trials, if an evaluation is hard, I think for litigants, the trial can be even more challenging.
Oh yeah, the stress of that, I can't even imagine.
The
Yeah.
stress, the expense, the formality of the legal proceedings, having all your information
Yeah.
out there. It's in a trial, it's very challenging for people. So, I think a best case scenario is always settling if you can.
Yeah, yeah, it sounds that way for sure. So any families or professionals might be listening that are preparing for an evaluation, do you have any tips or ideas of what can make the process more productive, especially for the children?
Well, I mean, certainly, I think being organized and if you have an attorney working closely with your attorney, sometimes people submit binders of evidence for me and well organized binders that I can look through and consider. Sometimes there are police reports in these cases, or arrest records, or CPS reports, making information available, showing up on time. Maintaining civility. I mean, usually that's how people are behaving. Uh, and just, cooperating with the process, cooperating with what the court has ordered.
Yeah, civility, that's a good tip, I think.
Civility, it's important in all aspects of our lives.
It really is. Yeah, we could use more of it, I
Well,
think.
yeah, so civility in all aspects of our lives, particularly in this process, because it's contentious is enough.
Yeah, seriously. Yeah, it can be very contentious. Yeah, that's good advice for sure. All right, well, that's it for today's episode of Bridging the Gap Law, Therapy, and Justice with Caitlin Burgess. To learn more about Caitlin's interdisciplinary work connecting therapy and law, visit CaitlinBurgess.com. There you'll find resources for families, attorneys, and mental health professionals involved in complex or high conflict cases. Thanks for listening. Don't forget to subscribe to our channel and leave us a review. We very much appreciate it. Caitlin, I always appreciate your time. Thanks so much
Have a
for being
great
here.
day. Talk to you later. Thanks, Kevin.
Thanks for watching. Be sure to hit that like and subscribe button and leave us a review in the comments.